from West Virginia Public Broadcasting.
Support for the following program is provided by the Stubblefield Institute for Civil Political Communications at Shepherd University.
Good evening and welcome to a forum among candidates for the West Virginia Supreme Court of Appeals. 3 justice seats are up for a nonpartisan election June 9th. This West Virginia Public Broadcasting production is sponsored by the Stubblefield Institute for Civil Political Communications at Shepherd University. Here now, West Virginia Public Broadcasting senior reporter Dave Mistich.
Good evening, I'm Dave Mistich, and I'll be moderating tonight's forum along with David Welch of the Stubblefield Institute. The June 9th election serves as the general election for candidates for West Virginia Supreme Court of Appeals. In the era of COVID-19, West Virginia Public Broadcasting is bringing you this candidates forum in the way many of us are communicating safely these days, through the use of technology that allows us to adhere to social distancing guidelines. There are 3 seats up for grabs in West Virginia for the Supreme Court of Appeals. Between absentee voting, early voting, and next Tuesday, voters will elect 1 justice from each of those divisions. So we're dividing tonight's broadcast into 3 segments, speaking with candidates from each division. We begin with Division 1.
Thank you, Dave. I'm here at the Stubblefield Institute for Civil Political Communications on the campus of Shepherd University. The candidates in Division 1 for Supreme Court are Chief Justice Tim Armstead, Circuit Court Judge David Hummel, and former Chief Justice Richard Neely. Due to technical reasons, Judge Hummel will not join the debate. Instead, he will offer comments immediately after. Justices Armstead and Neely are invited to do a 1-minute opening statement. We will go in alphabetical order, beginning with Justice Armstead.
Well, thank you. And first of all, let me thank the Stubblefield Institute for providing this opportunity to share with the people of our state our vision for the court. It's been a challenging 2 years for the court, obviously, in trying to restore confidence and integrity to our court in the eyes of our fellow West Virginians. But I believe we've made tremendous progress in doing so. We have put in place policies that are necessary to ensure that we don't have a repeat of what took place. We've reduced our budget, streamlined our budget, and gave money back to the people of West Virginia through the legislature, and made tremendous progress in ensuring that our court is run efficiently and ethically. And I believe it is important that we continue on this course. I'm honored to be a member of your state Supreme Court, and I would certainly be honored to continue to serve and to continue the forward progress that we've made over the past 2 years.
Thank you, Justice Armstead. Justice Neely, please, a 1-minute opening statement.
Well, it's hard to come up with much of an opening statement. What I'll simply do is tell you what I've done in life. I'm a graduate of Dartmouth College and Yale Law School. I was an Army artillery captain in Vietnam. When I came back and opened my own office in Fairmont, from the town from which I come, I then ran for the legislature and served 2 years in the legislature. And after that, in 1972, I ran for the West Virginia Supreme Court and served on the West Virginia Supreme Court for 22 years, during which five of which I was Chief Justice. So I've had a lot of experience in running the West Virginia court system. And I have a very different notion than Justice Armstead does of what the current state of the West Virginia court system is, and we'll talk about that a little bit later.
Thank you, Justice Neely, and thank you both. Dave and I will now be asking 3 rounds of questions. I will take the first round, and Dave will take the second round. Each question will be devoted or directed to a specific candidate who will then be asked to give a 1-minute reply. The other candidate will then have 1 minute to answer the same question or rebut the answer of the first candidate. We'll proceed in alphabetical order, beginning with Justice Armstead. Justice Armstead, West Virginia is one of the states hardest hit by the opioid drug crisis. How can the court be of greatest help in combating our opioid drug epidemic, and what additional resources and tools should the court be considering?
Well, that's a great question, and certainly it is a huge challenge for our state. What we've done, and I'm very pleased with, is that we've worked with the legislature to create family treatment courts. And those are courts that are existing courts. It's not a new level of courts, but it's circuit judges who work one-on-one with families to try to address the impact of the opioid epidemic on the children and on the families, and where it's possible to reunite the family. But that's not always possible, but where it is, I think we need to devote the type of resources that these family treatment courts have provided. They bring communities together, counseling services, DHHR. They bring accountability to those individuals who are struggling to overcome addiction, and to try to bring that family together. And I think that's an extremely important effort on our part. We have those in 5 counties now. They are working well, and I look forward to hopefully being able to expand on that program and make that more effective throughout our state. But I think we need creative approaches like that to be able to reach the families that are affected by the opioid epidemic in our state. As Speaker, I worked on that issue very intently as Speaker of the House, and I'm continuing to work on it through these family treatment courts as part of our judiciary.
Justice Neely, you now have 1 minute to answer the same question or to rebut Justice Armstead.
I don't have any rebuttal for Justice Armstead, but the one thing that I think is important is to try to make a really hard decision concerning who can be saved and who can't be saved.
Yep.
And at the very young child level, that's a pretty easy decision. Basically, all young children can be saved. And right now, what we need is a faster system of disposing of abuse and neglect cases. Right now, the dockets of the urban courts, Wheeling, Charleston, Beckley, Huntington, are dominated by abuse and neglect cases being handled by circuit judges who have not necessarily been trained in that. We can create a corps of special masters, of lawyers who have majored in psychology, nursing, education,
Neely,
sociology as undergraduates. Good. Anyway, that's what I would do.
Justice Neely, we're going to stay on you to answer first this next question, and then we'll go to Justice Armstead. Your question: some of the candidates seeking election to our state's highest court are claiming there are inordinate delays in getting appeals through the court. Do you agree or disagree that there are too many delays, or is the court functioning as expected by the citizens of the state, and can you provide reasons to support your position?
I'm the one who's alleged that there are inordinate delays. In fact, I can give you a specific example. I just received an opinion from the West Virginia Supreme Court in the case of Smith versus Gomez, where the appeal was filed on the 11th of May, 2018. And yesterday, which was the 25th of May, 26th of May, I finally got a decision. That's well over 2 years. So the court is indeed suffering an inordinate delay, and that's because they do not follow Article 8, Section 4 of the Constitution. Our Constitution lays out a very good, expeditious way of handling appeals. It worked very well for 150 years. The court, for some strange reason back in 2010, decided to mess with it and change it. And now everything is backed up and gets more and more backed up as more and more trash is assigned for full. Right.
Keep in mind we have a 1 minute limitation on these answers, and that's in an effort to try and get as many questions in as we can, given the time that we have. This next question will go back to, I'm sorry, my fault. Justice Armstead, you have 1 minute to answer the same question or rebut.
Well, we absolutely are not, do not have inordinate delays. We're right in line with what other states take in terms of the time for an appeal. What I believe my colleague is comparing is apples and oranges, because back at the time where the court did not issue an opinion on every case, they just simply, in many cases, gave a one sentence, "We refuse to hear the case." That certainly took less time, but it didn't give people opinions on their cases. And that's what our court is there for. And I disagree that I think we're very much consistent with our Constitution, which says that the court should look at cases and decide cases, and that they can decide a case whenever they believe there's a proper point for consideration. And so I disagree that we're behind. I think we're getting our work done efficiently, and we're hearing cases in every. And when my colleague talks about trash cases, I really take offense to that, because these are important cases to the litigants, and I think it's important that we hear those.
We're going to need you to wrap up. Yep.
Thank you very much, Justice Armstead. We're going to stay with you for this next question. And the question is, are 12-year terms too long for West Virginia Supreme Court Justice? And if so, how long should those terms be?
Well, I don't necessarily think they're too long, because I believe that anything we can do to remove the political influences from the court is a good thing. And I think that's the reason that we have long terms. Now, I'm always for accountability, and I think that the citizens of our state should have the opportunity to hold us accountable at the ballot box. But I do believe that if there's one area in our state, whether it be the legislature, governor, or other officers, that we should remove the political influence, it should be in our courts. And that's why when I was speaker, I oversaw the passage of making our courts nonpartisan. So I believe that a longer term is probably better, because it does insulate the court more from the political aspects.
Thank you, Justice Armstead. Justice Neely, same question, or to rebut?
No, I basically agree with that. And I sure as hell wouldn't want to be going through another one of these elections in any less than 12 years.
This next question is a question that I'm going to ask of both of you. We'll start with you, Justice Neely, and then we'll go to you, Justice Armstead. The West Virginia State Legislature considered, but did not pass, legislation to create a new intermediate court of appeals. The current Supreme Court has decided not to take a position on this issue. Without taking a position on any specific legislative proposal, do you believe West Virginia would be best served by creating an intermediate court, and why?
Absolutely not. The Intermediate Court of Appeals bill is favored and pushed by what I call the forces of evil. It's an insurance company bill calculated to make the West Virginia courts totally incompetent. If you think the delay is terrible right now, you get an Intermediate Court of Appeal and nothing ever would be finished for less than 4.5 years, which means that insurance companies that are utterly devoid of any character, utterly devoid of any honesty or integrity, and that's not all insurance companies, but that's a heck of a lot, they then would be able to settle for 15 cents on the dollar. The Intermediate Court of Appeals bill is not a statute designed to aid the judicial system. It's a statute designed to destroy the judicial system.
Thank you, Justice Neely. Justice Armstead, your response?
Well, first of all, I think that if you look at our Constitution, it gives the legislature, not the court system, the ability to decide whether there's an intermediate level of court. So I think that is uniquely a legislative issue. And that's one of the reasons the court decided not to wade into that issue in terms of taking a position. But whichever way the legislature goes in terms of doing that, we're poised and ready to assist that. If they decide not to implement that, we're getting our work done. We're getting the appeals processed, and we will continue to do so in an efficient and ethical manner. If they decide to implement such a court, we've stood ready and gave them the information necessary to make it work and to make it work effectively. So, I think that that is a a legislative issue that should be taken up by the legislature and addressed and determined whether, in fact, they believe there's a need for it. I do think that going back to one of the issues my colleague said, we need to continue to hear cases on their merits, and that was one of the reasons for that to be addressed originally.
Thank you, Justice Armstead. That will end our first round of questionings with Justices Neely and Armstead. I'm now going to send you back to Morgantown to Dave Mistich for round 2.
Thanks, David. Now we're the same format for this next round. We'll start with Justice Neely. Although nonpartisan elections of judges have now been with us for a few elections, political parties and partisan-leaning organizations continue to endorse and oppose Supreme Court candidates. Do you believe this interferes with the intention of nonpartisan campaigns, and should further reforms be considered? Justice Neely.
Well, in my experience, money is like water that leaks from a broken pipe in your roof. No matter what you do about it, it's going to get through your hardwood floors and down into your basement. But the truth of the matter is that I've just had $500,000 put into negative ads about me by the Republican something committee. It's an out-of-state Section 527 PAC. And as my grandfather said, people don't throw sticks at trees without apples. So obviously, these insurance companies are very frightened that maybe somebody will get on the court who will hold them accountable. But the idea that this is somehow nonpartisan, the name of the committee is the Republican State Leadership Committee, right? And you see it on the bottom of the ads.
Justice Armstead, would you mind to respond to that same question?
Well, first of all, I'd say that there are certainly a lot of money being spent by independent groups on both sides, and I'm being attacked as well. But what I would say about the idea of why that we felt it was important for judges to be elected on a nonpartisan basis was because, justice should be blind. It should be dependent upon the facts and the law and not upon a political leaning. At the same time, the Code of Judicial Conduct that governs all judges and judicial candidates in their state envisions that there will be endorsements made by various groups. And so simply because a particular group may endorse a candidate, for example, West Virginians for Life or the NRA, both of whom have endorsed me, those are endorsements that are given by the groups independently. They're not political endorsements in terms of Republican or Democrat. But there are various groups that feel very strongly about judicial elections, and they make endorsements. And I don't think there's anything improper about that. But I do believe that it was the right thing to do to make judicial races nonpartisan.
Okay, this next question will be for Justice Armstead, with Justice Neely an opportunity to rebut when we're finished. West Virginia leads the nation in the number of abused and neglected children who are without homes. In addition, our state's foster child situation is in crisis. How can the court play a role in getting children the help they need?
Well, that's a great question, a very important question. And we worked very hard with the legislature as a court system during this past session to give input on the foster care bill. And I'm glad we have that type of relationship where we can work together with the legislature to solve these issues. We do need additional resources, as I mentioned previously, about family treatment courts. They need to be able to have the tools necessary to be able to help those who are addicted free themselves from addiction and be able to provide the family resources and the family counseling services that may be necessary. Now, there are some cases where those children need permanently removed from those homes. If they're being abused, sexual abuse or physical abuse, they need to be removed. But there are times when, with the right treatment and help, that family can be reunited, and that's much less traumatic for those children. So I think we need to continue to identify those situations where that can be done, give the resources to the courts to be able to do that, and help them be able to address each and every child and make sure they have safe, healthy, happy homes.
Great. Justice Neely, would you like to respond to that?
Well, it goes back to the point I was making before about setting up a specialized court for doing abuse and neglect, at least in the urban counties where the circuit judges are overwhelmed. The need in abuse and neglect is to make a quick decision as to whether this family can be saved or whether it is a hopeless case. The quicker that decision is made, the better. Young children are much more adoptable and much more flexible if they are gotten out of a neglectful or an abusive house as young as possible. So abuse and neglect cases should be consigned to lawyers who have had training in fields like psychology as undergraduates. My own son is a lawyer, practices with me. He majored in psychology as an undergraduate. There are lots and lots of other lawyers who have majored in things like that. So a specialized court manned with people who understand these issues will go a long way to protect children.
This next question is again for Justice Armstead, and our final question will be for Justice Neely. Justice Armstead, can you talk about your familiarity with the business courts in West Virginia and whether you would consider creating other courts of limited jurisdiction to address specific cases like workers' compensation or family law?
Well, I think, first of all, I think the business court has been incredibly successful. I was in the legislature when we created those courts, that court, and I think it's been very effective in having a small group of judges who are very proficient in particular business issues, tax issues. Many of the cases that have come before our court that went originally before the business court have been tax-related cases, and they've shown that they have particular expertise in that area. And I think, I think it would be a good idea for us to identify certain judges, train them in particular issues, and have specialized courts that may address other issues. I think this has been a very successful court in our state, and I think it has done a good job.
Justice Neely, would you like to respond to that?
Yeah, I have no problem with the business court. We already have a specialized family court. And in my last answer, I was talking about setting up specialized neglect courts that would have real expertise in those areas. Past that, I can't see any area that is that has a sufficient number of cases every year to justify establishing a special court. The circuit courts, generally speaking, handle almost all the diverse issues that come before them in a more or less competent way.
All right, and this final question for this round will be for Justice Neely, and Justice Armstead will have the opportunity to rebut or respond. Should the state of West Virginia adopt sentencing guidelines and sentencing criminal defendants similar to the federal system? And should there be an increased use of alternative sentencing options for nonviolent criminals? Justice Neely.
There should be increasing use of alternative sentencing options for nonviolent criminals. I don't think that there's any need for sentencing guidelines such as the feds have, because from what I can see, those sentencing guidelines don't do anything that wasn't done before the guidelines were adopted back in the late 70s. There are so many exceptions to the guidelines, so many opportunities to deviate up or deviate down, or give credit for this or take away for that, that at the end of the day, they're simply an annoyance rather than a help. But
Justice Armstead.
Alternative sentencing, now that's worth considering.
Justice Armstead.
Certainly, I worked in the federal court system, and I believe that the federal sentencing guidelines were very helpful. And as a legislator, I've sponsored the legislation to create a sentencing commission that isn't a new branch of government. It's just taking prosecutors, public defenders, judges, and discussing ranges of sentencing, and that was actually enacted by the legislature this year. And so I'm looking forward to seeing how that is adopted. But I do think that some guidance in terms of sentencing and what, particular crimes that should fall within certain ranges of sentencing is important, as long as judges continue to have discretion to deal with the types of situations that come before them. Factually, there may be a situation where the guidelines simply aren't effective in that particular area or in that particular case. But I think that it is important to try to be consistent as much as possible in terms of sentencing people for particular types of crimes consistently, regardless of where in the state that may occur or what judge we're talking about.
Great. And that does it for the second round of questions. We'll throw it back to David Welch at the campus of Shepherd University and the Stubblefield Institute.
Thank you, Dave. Round three, we'll start with Justice Tim Armstead. The question is, Justice Armstead, court abuses and subsequent efforts to reform have been headline news the past several years. Do you believe further reforms in the state legal system are needed, and why?
Well, first of all, I think we've made tremendous progress, as I mentioned, in putting in place the types of guidelines and expectations from an ethical standpoint that are necessary, not only for the Supreme Court, but throughout our court system. And I think we need to, first of all, make sure we follow those and that we have the right checks and balances in place to make sure they're being followed. And I think we've done that, but we need to continue to do that, continue to make sure you can put all the guidelines in place you want, but if you don't follow them, they're meaningless. And we are making sure we follow them. So I think that is one of the things that we need to do. We need to also make sure that they're communicated well throughout our state to all judges and judicial employees throughout our state, and make sure they understand that we're going to lead from example and make sure that we follow them and expect everyone else to follow them. So I think that's the most important thing, is make sure that then there needs to be openness so that the people are able to identify whether in fact we are or are not following those guidelines.
To wrap up.
Thank you, Justice Armstead. Justice Neely, the same question or an opportunity to rebut?
No, there's no rebuttal. The point is that the average person doesn't give a damn about things like accountability, transparency. They don't even know what the West Virginia Supreme Court of Appeals is. They have absolutely no idea how the court system is administered unless they're lawyers or people who are involved somehow in the government. What they want is good results. They want a system that gives them speed, a just decision in a reasonable period of time. They want abuse and neglect cases disposed of quickly so that children can be saved. All of this window dressing of, how we're for Mother God and the American flag doesn't get fire on the target. As we used to say in the Army, it doesn't make any difference how shiny your shoes are or how well polished up your tanks are. If you don't put fire on the target, you're not doing your job.
This next question, thank you, Justice Neely. This next question goes to Justice Neely with an opportunity to, of course, respond by Justice Armstead. I'm standing tonight on the campus of Shepherd University in the Eastern Panhandle, an area of the state that is experiencing tremendous population growth. As a result, many observers claim our courts in the 23rd Circuit are overburdened. How should the reality of growing population in some areas and shrinking populations in other areas be addressed as it is to distributing the number of judges throughout the state? And that question goes to you, Justice Neely.
Well, for one thing, that's a legislative political question. I have answered the one thing that the court can do itself, which is create a corps of special masters to handle abuse and neglect cases. Abuse and neglect cases are what are dominating the dockets of the circuit courts and slowing everything down, as well as not getting those cases properly and quickly disposed of. With regard to the question of how you reallocate judges, et cetera, I think the idea of, quote, reallocating is dead at the entrance to the legislature because no county wants to give up a judge. You just have to eat the fact that in the counties that need help, you need to create more judges. And that's what we've done all along. We never have abolished a judge, but what we have done is create more judges. And if you're administering the court system correctly, when that happens and you have a bunch of unemployed judges in rural counties, you use them to send them around the state to take care of cases where judges are disqualified or sick, or just in general when you need additional judicial help.
Thank you, Justice Neely. Justice Armstead?
Well, thank you. First of all, I would say that I do understand the unique needs of the Eastern Panhandle. When I was Speaker of the House, a large part of my leadership team, my majority leader, and later my Speaker Pro Tem were from the Eastern Panhandle, and we shared a great deal of discussions about the needs of the Eastern Panhandle. In terms of the judges, we have a system in the legislature that is in the legislature now of prioritizing where the greatest needs are. And unfortunately, that at times does become a political issue because other areas may want to get a judge, even though they're not on the top of the list of the needs for the judge. But it's judges. But it's certainly clear that the Eastern Panhandle is near or at the top of that list. And as reapportionment of judges moves forward, hopefully they will follow the process and get the judges where they're needed, which is in the busiest circuits. So I certainly believe that if they do so, you'll see additional resources in the Eastern Panhandle.
Thank you very much, Justice Armstead. This next question will go to Justice Neely. The legislature passed judicial pay raises during the 2020 legislative session that increases the salaries of Supreme Court justices, circuit court judges, and family court judges over the next few years. Are you satisfied that the pay raises are sufficient to retain and recruit new judicial candidates?
Well, I have no real data on which to make a conclusion. It seems to me that people become judges for reasons other than money. Unfortunately, a lot of the people who become judges for reasons other than money aren't really very good judges. But I don't believe that raising salaries will necessarily get you a better group of judges. I was in the legislature. I was elected to the legislature when the legislature made $500. And the salaries in the legislature have gone up consistently. And I've never noticed that the legislature that's elected with the salaries at $25,000 or $30,000 a year now is a bit better than the legislature that was elected when it paid $500. So I don't have any strong feelings about that. This election has cost me $500,000.
Justice Armstrong, an opportunity to answer the same question or to rebut.
Well, I think that when I was in the legislature and when I was Speaker, we recognized that it was not the best situation to have judges coming to the legislature when many of the legislators were in fact attorneys that had to practice before judges in our state. That was not the best situation for judges to come hat in hand asking for pay raises. So we created the Judicial Compensation Commission, which is the independent group of people who are not judges that look at data on a periodic basis and determine what judges make in other areas that are similar in population and similar in caseload. And they came forward with a recommendation, which then gives the legislature solid data, not simply political data in terms of who is pushing for a raise or not pushing for a raise, but this is solid data based on research that was done. And I think that was the right approach to move forward, is to have that independent approach that the legislature then has the data they need to make that decision.
All right, gentlemen, thank you both for all of these answers. We're going to now move along to some closing statements. You will now each have 1 minute for a final statement. We'll go in alphabetical order again, beginning with Justice Armstead.
All right. Thank you again for the opportunity to talk with our fellow West Virginians. Again, this is a race that's incredibly important. It's a decision as to whether this court moves forward in the manner that we've already started in restoring confidence and the integrity and efficiency of our court. That we continue to follow the rule of law, not make law from the bench, but follow the law and interpret our laws and our Constitution and uphold our Constitution. That's what this election is about, and it's a decision of whether we're going to continue to go forward or we're going to go backwards. And it's incredibly important, I think, that we move forward. I have been honored to be a member of this court for nearly 2 years now, and I would be honored to continue to represent people of our West Virginia on their Supreme Court, continue to move it forward, continue to follow the rule of law, and to do it ethically and responsibly and efficiently. So I would certainly ask for your support and would be honored to continue to be your justice on your Supreme Court.
And now, Justice Neely, this is your opportunity to offer a closing statement.
Well, I've said most of what I want to say in the course of the discussion. I've been perhaps a little more strident than other people, but that's because I really believe the court system is in a shambles. I believe that the Supreme Court has the authority to provide quality control to all of the circuits. And out in the circuits, many circuit courts are simply black holes into which litigation goes and never comes out. There are courts that have motions under consideration for a year or two or even 3. All of these things have to be fixed. And so I don't want to talk platitudes. I don't want to tell you how much I love Mother God and the American flag. What I want to do is get on the court and put some serious fire on the targets. And I thank you all for listening to this.
We certainly want to thank Justices Neely and Armstead for a great discussion. And as we said before the forum began, Judge David Hummel was not able to join this discussion. However, we did catch up with him later, and I wanted to welcome in now Judge David Hummel. Yeah, let's start off with just a 1-minute opening statement, Judge Hummel. Introduce yourself and tell us why you're running for the Supreme Court.
Certainly. I'm Judge David Hummel, and just that, I am a circuit court judge. Turned 50 the other day and realized that for the decade, my entire decade of my 40s, I've served as a circuit court judge. I was elected in 2008, so I've been on the bench now 12 years. And I believe that experience as a circuit court judge qualifies me. And although it's not a requirement, I think it's very important to be a Supreme Court justice in the state of West Virginia, our highest court. You need to have been in the trenches, served. And I've served now 12 years in the trenches as a circuit court judge, and I know what happens in a courtroom. I also serve as a treatment court judge, and I have for 12 years as well. Drug court, mental health court, we've combined them for treatment court. And the experience I've gained through that, I believe, is invaluable, and it's something our state needs to further advance its attack, its defenses against mental health and drug addiction issues.
Judge Hummel, you brought up mental health. As you know, West Virginia is one of the states hardest hit by the opioid drug crisis. How can the court be of greatest help, in your mind, in combating opioid drug epidemic, and what additional resources and tools can the court consider at this time?
Absolutely. As is the presiding judge in the Second Judicial Circuit, Marshal Wetzel Tyler, I also handled the largest ever opioid case in the state of West Virginia. It's now been transferred to the multi-district litigation or mass panel here in West Virginia. Working on that case, I realized that more so that this is a medical issue. Addiction is truly a medical issue. So I have taken our drug court and turned it into a treatment court. So we work on co-occurring issues, mental health issues, and also addiction. With that, I turned from a day report center to a behavioral health center for the services. We have services of professionals, psychiatrists, psychologists, master's levels. We are the only circuit doing this. And this is something it's not rocket science, but this decision needs to be made statewide. We're being used as a model here. It's innovative. It's saving money. It's saving lives. most importantly, it's saving families and communities. So I believe that statewide, we should turn to a behavioral health center to provide services with the professionals necessary to attack this demon that is addiction.
You are running for the Supreme Court in a division that has a current Chief Justice in it and also a previous Chief Justice in it. So this is a division with a lot of experienced jurists running. What distinguishes you as a judge in the circuit court level against these two Chief Justices that you're opposing?
Certainly. It's been in the trenches. I have 12 years now of making decisions in a courtroom. The other two have never made a decision in a circuit courtroom. They've never sat again, across the bench from litigants whose families have been ravaged by mental health and drug issues that find themselves either in abuse and neglect cases or criminal cases. Respect both gentlemen, Chief Justice Armstead, as well as former Chief Justice Neely. And no question, they do have experience as Supreme Court justices, but neither have any experience whatsoever as a circuit court judge. And even the manager at McDonald's knows how to cook the fries. So I think it's a ground up approach to being a Supreme Court justice is the time and energy I've put in being a circuit judge, making those decisions that affect lives. I boiled down being a circuit judge to the basic thing. And one of the things is I decide where people sleep, whether it's in prison, in jail, where they see their children or not again. These are heavy decisions that I'm experienced and have been making for the last 12 years.
Judge Hummel, just as we provided the other two candidates in Division 1 with an opportunity to make a closing statement, we'd like to offer that opportunity to you as well.
Thank you so much for this opportunity. In total, I look forward to serving as a Supreme Court justice. I'm really happy doing what I do as a circuit court judge, but I know that the experience that I have gained will further advance West Virginia. And to be sure, I'm a circuit judge with 12 years experience. I run treatment court. I don't just talk about treatment court and I don't just support it. I run it. And moreover, there's not a justice on the court currently and no one in this candidacy right now that lives above the Kanawha Valley. So the North is not underrepresented, but we're entirely unrepresented. And we need to have representation in Charleston. And I hope to be that.
Judge David Hummel, thank you very much. We apologize for the earlier technical errors. And that will wrap up our discussion for Division 1 State Supreme Court candidates. We are now going to send this back to Morgantown to Dave Mistich for the discussion with the Division 2 Supreme Court candidates.
Thank you, David. We'd now like to welcome 4 candidates for the West Virginia Supreme Court of Appeals Division 2. The candidates are Kanawha County Family Court Judge Jim Douglas, Putnam County Assistant County Prosecutor Christina Chris Rains, Kanawha County Circuit Judge Joanna Tabbitt, and former Senator William R. Bill Wooten. Each of the candidates are invited to do a 1-minute opening statement. We will go in alphabetical order, beginning with Judge Jim Douglas.
Thank you very much for having me. I am Jim Douglas. I am a current and sitting family court judge in Kanawha County, state of West Virginia. I am running, I guess it would be appropriate, my opening statement to say, so that the family law can have a justice on the West Virginia Supreme Court of Appeals. We've got 2 12-year terms that are up. That's one in Division 2 as well. And that is a long time to go without an experienced family law justice sitting on that court. The other thing that I consider or ask you to consider is that 50% of all civil appeals that are filed in the West Virginia Supreme Court are family law / domestic relations. Also, the family law appeals to the West Virginia Supreme Court have for the last several years run more than the criminal appeals. So it is absolutely imperative that someone be on the Supreme Court that has that experience. With all due respect to everyone involved, I have more practical trial experience in family law cases than anybody else.
We're going to need you to wrap up.
In my opinion. And I have collected child support cases and
we're going to need you to wrap that. And Assistant Prosecutor Rains.
Hello, my name is Chris Rains. I am an assistant prosecutor in Putnam County. I will tell you that I am the sole conservative in Division 2 race. My opponents all have Democratic political pasts. I am endorsed by the West Virginia Republican Party, West Virginians for Life, the West Virginia Family Policy Council, and the Associated Builders and Contractors, as well as a few other online endorsements that I've recently received. I am a constitutional textualist and originalist, which means that I believe in interpreting the plain meaning of the statute and the Constitution. I'm a big endorser of separation of powers. I believe the judicial branch should interpret and reasonably apply the law, not to create the law from the bench. I would indicate that in my experience as a prosecutor for 20 years on the state and federal level, I've tried numerous kinds of cases. The majority have been.
And time.
Thank you.
And Judge Tabbitt, your turn.
Thank you. And I'd like to thank everyone at the Stubblefield Institute for working to get this forum together. My name is Joanna Tabbitt. I am a circuit court judge in Kanawha County. I am a lifelong West Virginian and am running for Justice of the Supreme Court of Appeals to improve life for all West Virginians. Because I believe that now more than ever, our court needs proven, qualified judges, circuit judges who have the breadth of experience to have considered all the issues that come before our Supreme Court daily. As a circuit judge for over 5 years and a lifetime courtroom litigator prior to that time, I bring a wealth of experience to the court and have the integrity, experience, and energy to lead it into the next generation. I've served and been appointed as an acting Supreme Court justice on a number of occasions by our Supreme Court Chief Justices. I know firsthand the work, how to do it, and I know it's on the job training. So I look forward to the discussion. Thank you very much.
And former Senator Wooten, your turn.
Hello, I'm Bill Wooten. First, I want to thank the Stubblefield Institute at Shepherd University and the public broadcasting system for making this forum possible. Also want to thank the viewers for your attention and consideration. I'm a small town lawyer, and I've been involved in the practice of law for a long time. I think I have probably been involved in every type of legal proceeding possible in the state of West Virginia. And I've got a track record of public service. I'm a retired colonel from the West Virginia Army National Guard. I served 26 years in the legislature, including 10 years as chairman of the Senate Judiciary Committee. I'm most proud of the fact that throughout my legislative service, no one ever even questioned my integrity. I gained firsthand experience in the appellate court system. I worked as a law clerk for the Honorable John A. Field, Jr., a judge of the United States Circuit Court of Appeals, which is one level below the U.S. Supreme Court. I've worked as a prosecutor. I think I convicted probably West Virginia's most notorious criminal, Ronald Williams, for the murder of a Vector police officer. He gained his notoriety when he escaped from Mountsville and murdered Philip Kennedy.
Thank you, candidates. Due to some technological constraints with our video conferencing platform, David Welch at the Stubblefield Institute at Shepherd will have to put his duties as moderator on hold for this division's discussion. Because of that, I'll be moderating the discussion between Division 2 candidates on my own. Each question asked will be directed to a specific candidate who will be given 1 minute to reply. The other 3 candidates will then have 1 minute to either answer the same question or rebut the answer from the first candidate. We're going to begin with this first round of questions with Judge Jim Douglas. And here's your question. On matters ranging from the environment to business and labor, to children and families, to education and many other issues, the work of the West Virginia Supreme Court potentially affects the lives of all West Virginians. Without taking a side on any political issue or discussing a specific case, what do you perceive as the most important issue areas coming before the court in the next several years? Mr. Douglas.
To me, it's very clear. It's family law issues. One, I think that the family courts should be at some point in time be considered to be placed on parity. They'd have to do that legislatively with with the legislature to be able to handle this explosion of abuse and neglect cases. If we're on parity and then we're in the family law division permanently, then that can be done, but that's a legislative prerogative. Second thing is the proper funding through the Supreme Court's budget, not through the legislature, funding for the foster care families. Second of all is proper funding for guardians ad litem. That's attorneys that represent children. Also stipends in the Supreme Court's budget for guardians, like grandparents that have to come in and get a guardianship. It's called a FIG, Infant Guardianship and Family Court. There's also an analogous procedure in circuit court. And then the other thing is the separation of powers. I believe that the separation of powers, I believe that the Workman versus Carmichael decision was wrong.
And
I realize that's not the policy.
Right. We'll move on to Assistant Prosecutor Raines. 1 minute.
Thank you. I would agree with Judge Douglas that abuse and neglect cases are the most important, as well as drug addiction and opioid crisis in our state. I would take issue with the statistics that Judge Douglas has indicated that 50% of the 50% of the cases that go to the Supreme Court are family law related. They are indicated in the family law category. However, the large majority of those cases in the family law category, I'm checking the stats right now, are abuse and neglect cases. Those are not handled by family court judges. They're handled by prosecutors and circuit judges. So the majority of the cases that the court will hear are criminal appeals and abuse and neglect cases, all handled by prosecutors.
All right. And now we'll move on to Judge Tabbitt.
And I don't disagree with what Prosecutor Raines just said. Absolutely, child abuse neglect cases are really the biggest issue before the court. And that is related to the opioid crisis and the addiction issues that we are facing. But 60% of the cases before circuit courts today are stemming from child abuse situations. And the family is the foundation of everything. So in my view, those are the most important cases that we do here. I think that also the issues with respect to treatment courts, particularly family treatment courts, are critical going forward as it relates to issues before the Supreme Court, because it deals with the issue of child abuse neglect and also deals with the issue of substance abuse, which both are the most significant issues, in my opinion, that are facing the court right now and the court system as a whole.
Great. Senator Wooten, 1 minute.
West Virginia right now has a pandemic problem that's critical across the nation. But the underlying problem in West Virginia that is responsible for the growth in the abuse and neglect cases and most of the other domestic relations cases is the underlying opioid crisis. That problem has to be dealt with. The magnitude of the problem is beyond the scope of the judicial system to deal with it. The executive branch and the legislative branch must find more creative and effective methods of dealing with it. That being said, the judicial system can make a significant contribution to dealing with the opioid crisis, which I believe will help with the abuse and neglect and the other domestic relations matters. That's our biggest problem as a state. I think the court's done commendable work so far with drug courts, veteran courts, and those. I think we need to continue that to the extent we have resources available. The court system needs to put more resources in it. Thank you.
And time. This next question will begin with Assistant Prosecutor Raines. 3 of the 5 current Supreme Court justices had not served as judges at any level prior to assuming their tenure on the state's highest court. Should bench experience be a prerequisite for voters trying to decide which candidate to vote for? Or are there other equivalent experiences that voters should consider?
I do think that judicial experience has some merit. However, like you said, 3 of the 5 justices that are now on the Supreme Court have never been judges before. 2 of those judges have brought forward sweeping reform of the court after the impeachment scandal or implosion of the judiciary a couple of years ago. Chief Justice Walker enacted a personnel and policy and procedure manual that most small businesses have, but the Supreme Court didn't seem to have at that time. And Chief Justice Armstead also put forward a purchasing policy to keep the court on par with other state agencies in West Virginia. So I believe their quote unquote on the job training experience has been pretty successful in reforming and restoring integrity to our court. I think I can be just as successful in bringing that accountability skill set that I have attained over 20 years as a state and federal prosecutor to the court. That's what is the beauty about having 5 justices
Judge Tabbitt?
I believe the judicial experience is critical. Now more than ever, as I've said, our court needs proven qualified judges, and that's why I'm running. Basically, the Supreme Court is reviewing the decision of circuit court judges. It's important for an individual sitting at that appellate level to have sat at the level I'm at right now as a circuit judge and made those decisions at the court, called the balls and the strikes. It, in my view, is critical. And I have the experience and I have the integrity to lead the court. I've actually done this, as I indicated. I have been appointed as an acting Supreme Court justice, and I have found that my experience as a circuit judge certainly helps, and I believe it's critical to the success of the court. And that's one of the reasons I'm running.
Right. Senator Wooten, you're up next.
Our circuit court judgeship experience, is useful, but it's not critical. I think 3 of the 5 judges, including the 2 that Ms. Raines mentioned, have had no circuit court experience. Some of the most outstanding United States Supreme Court justices never served as a judge before being on the Supreme Court. Hugo Black, Felix Frankfurter, Earl Warren, a host of others. I think what's most important is that the judge have experience in just about every phase of the practice of law. And I think that's the strength of my candidacy. I think I've been involved in every possible type of legal proceeding that a West Virginia lawyer can be involved in. The breadth and scope of my experience is greater than that of any of the other candidates. Thank you.
Judge Douglas, 1 minute to answer the same question or rebut.
It'll be a combination. First of all, there's nothing magical about being a circuit judge to serve on the Supreme Court of Appeals in West Virginia. Justice Cleckley, Justice Miller, Justice Harshbarger, none of those people were circuit judges before. What I think is significant is there's never been a family court judge or someone with substantial family court experience on the Supreme Court to have that many cases to have to deal with. I disagree with respectfully Ms. Raines about all these plaudits she gives the existing justices. So those are administrative matters. You have to deal with real guts and nuts and bolts and blood cases where you've had crime, where you've had divorces. I'm a former prosecutor. I disagree with Mr. Wooten respectfully. I've had a lot of experience in all kinds of areas, including condemnation, car wrecks, slip and falls. I've done boundary lines. I've done a lot of special ed law, as a matter of fact, and nobody else has. You can elect any one of these individuals in Division 2, where it's a judge, prosecutor, or former legislator. You can only elect one family court judge. That's me.
This next question will begin with Judge Tabbitt. What changes or reforms would you like to see in the West Virginia Supreme Court and the judicial system in general? And also, please explain your answer as to why.
Sure. I think that it's important to take a look at the recusal system at the Supreme Court of Appeals. And a recusal is when a judge perceives that there may be a conflict upon him or her hearing a specific case. And right now, the sitting justice can make that decision himself or herself with no review and no accountability. I think it's important for a justice who is deciding to sit on a case to explain the reasons why he or she believes it's appropriate for him or her to sit on the case. And I think it's important for also there to be accountability in the rest of the court taking a look at that decision and making a determination as to whether or not that's appropriate. I don't know that it needs to be the entire court. Perhaps a majority is sufficient. But I do believe accountability is important. Our Supreme Court has gone a long way in these last 18 months to restore accountability in the process, and this would be part of that in my view. It instills public faith and confidence in the judiciary and in the process.
Senator Wooten, 1 minute to answer the same question or rebut.
Well, I think the structure is basically sound. I disagree with Judge Tabbitt with regard to the recusal system. Our recusal system in West Virginia is exactly the same system as the United States Supreme Court has. I would be troubled by the fact that that 3 judges could vote to excuse me from sitting on a case. I don't disagree with the suggestion that there perhaps ought to be a written opinion by the judge who is asked to recuse himself if he declines to do so. I think that could be put on the record. I think transparency is always good, but I would disagree with allowing the fellow judges to vote someone off and to allow someone else then to be on the panel, which is what would happen. I also think we need to encourage more transparency. All of us know that in 2018, our Supreme Court was shaken by some fiscal scandals, outrageous spending. I think if we had complete transparency with regard to all spending, travel, or all furnishings, or office refurbishing, I think that sunshine of transparency would end that problem. Thank you.
Right. Judge Douglas, 1 minute to answer or rebut.
I don't think recusal is the most pressing issue for the West Virginia Supreme Court of Appeals. The United States Supreme Court spoke to that in the Caperton case, that to the embarrassment of the state. There's two things I think Supreme Court needs to do. One is up its visibility to the average citizen in the state of West Virginia. Historically, we've had and held arguments. I've participated in arguments before the Supreme Court, over 40 cases before the Supreme Court. And we've gone to different places like Morgantown, we've gone to Charleston, but why can't you hold court in any of the courthouses across the other 55 counties, whether it be Grantsville, whether it be Princeton, whether it be Marlington, and let people see that the Supreme Court is people by real persons, real humans. The other thing I said is what I alluded to earlier is that I'd just like to see the court improve by making all family court judges on parity with circuit judges, have the same pay, same retirements. They're just permanently assigned to the family law division. That way you have people that have knowledge of family law making family law decisions. This thing about the current justices learning on the job about family law is untenable.
Assistant Prosecutor Raines, you're up next.
Thank you. I think that I would take what the court has started with the treatment court programs and study and try to identify some of the weaknesses and shore up those weaknesses to try to allow our recovery people in recovery more success. They're successful when they're in the treatment courts. They are monitored for a very short time afterwards, but then they tend to slip back. They tend to relapse, which is part of recovery. So I would try to institute some kind of study to look into that more, to see if longer supervision would be helpful in that regard, job skills, and some kind of community corrections program in order to identify and try to eliminate that problem.
All right. Moving on to the next question. This one will be for Senator Wooten. Some of the candidates seeking election to our state's highest court are claiming that there are inordinate delays in getting appeals through the court's process. Do you agree or disagree that there are too many delays, or is the court functioning as expected by the citizens of the state? And can you provide reasons to support your position?
From my personal experience, I've never had an inordinate delay in an appeal, and I've prosecuted a number of appeals to the Supreme Court. I don't think that's a valid criticism. I think that obviously this pandemic has slowed the processing of cases, but I think in general the court's relatively efficient. I don't believe there is. Some people use that argument as justification for another level of appellate courts. I don't believe that we have an inordinate delay in the processing of appeals. Thank you.
Judge Douglas?
I follow primarily the family law cases, as you well imagine. I know it sounds like an old saw at this point in time, but I'm not so sure it's an inordinate delay, but it's an unusual delay. I tracked a number of cases, 2018, 19, and 20 before the pandemic, and they were averaging out about 14 months for filing. What bothers me is that these justices, the United States Supreme Court has 3 clerks for each justice. Right now, they call them different names, but the West Virginia Supreme Court of Appeal has 4 clerks for each justice. I don't see why they can't act more expeditiously than what they are. The last family law case that was decided and handed down was April 20th, and before that, it was April 6th, and there's only been 12 decisions come down since the beginning of this particular term in January. So there is some delay here. It could be better.
Assistant Prosecutor Raines?
Well, I would like to respectfully disagree with Judge Douglas. 12 family court cases being decided since January is almost half of what they the total number of family court cases that the court heard in 2019. So it sounds like they're doing a pretty good job at handling those types of cases. I think that the court has some responsibility in that, but I also think that the parties requesting additional time to file, to reply to these certain to these certain appeals aren't factored into the time level as well. So I believe that the court is getting better at their timeline in answering appeals.
Judge Tabbitt.
As a lawyer, I handled probably 40 to 50 appeals in both civil and criminal cases, and I never found there to be an inordinate delay in getting a decision from the court. And of course, as a circuit judge, the parties appeal my cases, and I pay attention to them and track them as well. And my experience has been similar. I've not found there to be inordinate delays. And the rules were revised. The rules of appellate procedure were revised 10 years ago, and the court is hearing all cases, and in my view, seems to be managing its docket.
Thank you all for your answers. We'll now go in reverse order for another round of questions and rebuttals, reverse alphabetical order, I should say, which means we'll start with former Senator Wooten for this next question. I'll call on the candidates individually when it is their chance to respond. Senator Wooten, the West Virginia State Legislature considered but did not pass legislation to create a new Intermediate Court of Appeals. The current Supreme Court has decided not to take a position on this issue, and without you yourself taking a position on any specific legislative proposal, do you believe that West Virginia would be best served by creating this intermediate court, and why?
The voters amended our Constitution in 1974. I think it's called the Modern Judiciary Amendment, and that constitutional amendment expressly provided for an Intermediate Court of Appeals. But it's up to the legislature to enact it. In all the time since 1974, the legislature has not seen fit to do so. I think the legislature has been wise in that action. Each of the candidates commented during the last question, we believe the Supreme Court is able to manage its workload at this level. The state does not have a crying need for another level of the judiciary. Therefore, I believe it's wrong to saddle the taxpayers with the expense of an additional level of judiciary. That being said, the decision is properly a decision to be made by the people through their elected representatives in the legislature. If I'm elected, I'll comply with whatever the law says, and I don't think it really is appropriate for me to advocate one way or the other with regard to that question.
Judge Tabbitt.
And it really is the decision as to an Intermediate Court of Appeals. It's a legislative decision. But as I said in response to the previous question, I believe that the court is managing its docket. 10 years ago, our rules of appellate procedure were revised, and now our Supreme Court hears all cases that come before it. It has not refused an appeal in that 10 years. So people are having the opportunity, litigants are having the opportunity to have access to justice and have their cases heard. And I do believe the court's managing its docket.
Assistant Prosecutor Raines.
Like Judge Tabbitt and Senator Wooten, I would agree that that is a legislative issue to take up. I would indicate that I've researched this issue, and I understand the arguments both for and against. I know that as far as states in the union that do not have intermediate appellate courts, we are one of the few. But I also note that due to the high level of criminal case appeals, as well as abuse and neglect appeals, all coming from circuit courts and judges, that perhaps civil cases may suffer in not getting appeals with syllabus notes that make case laws. And again, the argument on the contrary is that all our cases are being currently answered by our Supreme Court, so there is no need. So I would abide by the plain text of the legislature, whatever the legislature decides to do on this topic. I don't believe. Okay.
Judge Douglas.
Well, what all can I add? I mean, a couple of things that come to my mind on it when it's looked at. I respectfully disagree with Judge Tabbitt about the change of the rules and all the cases being heard. All we get is probably about 80%. I never ran a precise calculation, but I'm confident in that figure, of memorandum opinions, not signed opinions that go in the Southeastern Reporter or the West Virginia reports that they come out. So, what's the value of the memorandum opinions as far as the lawyers and the predictability function and trying to tell their clients what they should do and plan? I think probably we would be better served, instead of an intermediate appellate court, go back to what it was before December 2010, where you had to petition to get in. Then when the decisions came down, they had precedential value. The other thing, is it really fair to add another cost, a layer of cost to litigants, and add another period of delay to litigants? I think that's inherent, without saying which way I go on this opinion, of course, or this issue. But that's inherent to this particular concept and this particular institution, the Intermediate Appellate Court.
This next question is for Judge Tabbitt. How do you see technology playing a role in the future of the West Virginia judicial system to make the courts more efficient and effective? You have 1 minute.
It is critical, and certainly with this recent pandemic, we have seen it through full force. And the IT department, particularly the director of information technology, the court has done a great job. I know that as a sitting circuit judge, we really didn't miss a beat. We've had video hearings, and since the judicial emergency has been lifted, we have been able to do everything that we did before except hold jury trials, and I'm sure we will work to make accommodations, hybrid courtrooms and the like, to do that. But it is all about access to justice, and what we have learned from our recent pandemic is that we all can do this, and we all are learning to work differently, and it's frankly successful, but technology is the key, and it's going to be, in my view, an important component administratively of what the court does going forward, from the top down: Supreme Court, Circuit Court, Family Courts, Magistrate Courts, all the way.
Assistant Prosecutor Raines, your turn.
I agree with Judge Tabbitt that the Supreme Court has done a wonderful job in incorporating technology during this COVID-19 pandemic. I've had Skype hearings on all critical criminal cases that we have heard, mostly for people who are incarcerated, and there is Skype access in the regional jails and the penitentiaries in which I've heard hearings. I think that in continuing this technology, it may perhaps, maybe civil pretrials can be handled this way. Maybe scheduling conferences can be handled this way. And that would help that would help circuit court judges manage their dockets a little bit better and cut down on everyone having to come to the courthouse for these hearings that are not dispositive or adjudicatory.
Judge Douglas, 1 minute.
Well, first of all, I want to commend Pat Moats at the Supreme Court, the IT director, for the job she's done. But I see there are inherent constitutional issues in this technology. We still have the Constitution that says, like in criminal cases, that you can confront your accuser. Well, does a Zoom confrontation comport with that constitutional provision? Second of all, trials are to be public. That's one of our greatest protections in criminal cases. They're public. How can it be public? How many people can you get on a Zoom for a public trial? It's unbelievable. The third thing is that I have to look, and I've been doing a number of divorce cases and domestic violence by Zoom. You can't really make proper credibility assessments looking at witnesses and parties, because if the evidence is conflicting and it's a close call, then those credibility assessments can't be made over a distance with 1,080 pixels. That's the problem with the technology.
Time. Senator Wooten.
With respect to this pandemic, public broadcasting made this accommodation, and the courts have done the same thing. With regard to prisoners having appearances, that predated the pandemic. That we've had the ability in this state for prisoners to be arraigned at a regional jail without personally appearing through video conferencing for some time. With regard to scheduling conferences, it's been my experience over the last several years that most scheduling conferences prior to the pandemic were conducted by telephone. So I don't think those are the technology issues that are on the forefront. I think the major technology issue in this state now is the problem of, or not problem, but the process of converting to electronic filing, to e-filing. And the court is in the process of doing that county by county. I think my county is in the next phase of that. The federal court's had that for some time. Our state Supreme Court has made several false steps in attempting to do that. I hope that that the current process works better than it had. We need more involvement with circuit clerks.
That'll be time. And this will be one final question for all of you, and then we'll move to closing statements. Although nonpartisan elections of judges have now been with us for a few elections, political parties and partisan-leaning organizations continue to endorse and oppose Supreme Court candidates. Do you believe this interferes with the intention of nonpartisan campaigns, and should further reforms be considered? We'll start this answer with Assistant Prosecutor Raines.
Because this is a nonpartisan race, and because of the judicial ethics canons, candidates are not able to give a lot of information about themselves, about their backgrounds, to voters in order for voters to make an informed choice. That's where endorsements come in. That's where our backgrounds come in, as far as our political backgrounds leading up to this race. I think that eliminating that would eliminate the one sole way that people can distinguish one candidate from another. It has been upheld by the Judicial Investigation Committee that endorsements are proper, that we may talk about our how we are registered to vote. And I do think that eliminating that for the voters is detrimental to getting to see just a little bit about, a little bit more about.
All right. We'll go now to Judge Douglas.
Well, let's face reality here. I'm 69 years old, and and everybody's listening to this knows how every candidate in this division is registered, what party they're affiliated with. Look at who the Republican Executive Committee on the state levels endorsed. Did they endorse any Democrats in any division? No, they did not. And I take a position, I've taken it before, that endorsements, I didn't seek them actively. I filled out questionnaires I thought people should know, but endorsements are expected to be paid for at some time by a judge. Look what happened to poor Justice Hutchison when he came down in his decision on the wrong side of the right to work case that just recently came out. I think there should be some proscription about endorsements or the publications of them or something like that, because all that means is that's just a big popularity contest for who's going to stand in line with their hand out first to get a payback.
And we'll now move on to Senator Wooten.
I think that if you're going to have nonpartisan elections for judicial officers, as mandated by our state laws, neither political party should become involved in a partisan sense in endorsing a candidate. I think that makes a mockery of having it nonpartisan. I'd also suggest that judicial elections in this state have never been partisan. That's just not the nature of a judicial election. I think that having a quote nonpartisan election coinciding with the primary, and that being the only election, I think that deprives the voters of the opportunity to learn a sufficient amount of knowledge about the candidates to make informed choices. It's very tough to communicate with voters in a crowded field where whoever wins will very likely not achieve a majority. This is the third different cycle of nonpartisan elections. No one's ever been elected with a majority.
Right. And this will be, and to close this discussion out, we'll have Judge Tabbitt.
Sure. And I agree with Senator Wooten in that I do not believe political parties should become involved in this nonpartisan judicial process. But does it happen? Yes. I mean, we see 527s, out-of-state companies coming in with gray money and even earmarking themselves and naming themselves as a particular party, supporting particular candidates. But I also want to respond to what Judge Douglas said with respect to the endorsement process, because I want to speak to my endorsements. I'm a consensus candidate, and I'm a consensus candidate that's received endorsements from business, labor, law enforcement, first responders, healthcare providers, teachers, social workers, and that's because people have seen my history as a circuit court judge. They know that I apply reason, thoughtfulness, and fairness in every case that's before me. So I've got endorsements from everyone as a consensus candidate, and I think that speaks volumes about my candidacy. Thank you.
Thank you. We will now move on to a final statement from each of you. We'll allow 1 minute for each candidate, and we'll return to alphabetical order, beginning with Judge Douglas.
Thank you. And again, thank you for having me. First of all, I'm coming back to my first love, which is family law. We have to have a family law representative on the Supreme Court. We can't go 12 years and not have one. So that some justice will say, what about the kids, to the other 4 that don't have the experience, practical experience? I've had it in a lot of areas, but family law is where I'm mostly at. I want everybody to imagine, if they can right now, how many people do you know that have been engaged in felonies? There's a number. If I ask you how many people you know has been engaged in divorces, that number is a heck of a lot higher. Do you want someone on the Supreme Court handling your granddaughter's case that's never been very close to trying a grandparent case, or several of them, as I've tried? I've had the trial experience. I've got the judicial experience. I'm the only family court judge. Who are you going to pick if you don't pick me to handle the family court issues? I'm a father, a grandfather, and a divorcee. So not only do I have the academic experience, I have the real life experience. So I've sat where you sit, where you sit.
We'll move on to Assistant Prosecutor Raines.
I think these voters are entitled to know that we all went to law school. We are all qualified for this position. As far as not having family court experience, I'll indicate that there were 26 cases heard in 2019 based on family court. There were 45 cases based on family court in 2018. The criminal appeals from those times were 220, and the abuse and neglect were 278. Those are handled by criminal prosecutors. Also, as far as endorsements are involved, no one needs to be endorsed by a political party. All you can do is check our campaign finance reports. You can see who are the main donors and see who perhaps judicial candidates are beholden to. So as people are voting for a majority of the court, do they want someone who is handpicked by trial lawyers, in which the trial lawyers will argue their cases in front of, or do they want somebody who has constitutional conservative value?
We'll move on to Judge Tabbitt.
Thank you. And this election, as we discussed, is historic. And it's historic because for the first time in 25 years, we're going to be electing a majority of our Supreme Court. 3 out of the 5 Supreme Court justices. That's 28 years, an entire generation of jurisprudence that will be making decisions that affect West Virginians for years beyond that. So voters need to be thoughtful about who they put in these positions. And I am an individual with experience, integrity, and a sense of fairness and energy to lead the court into the next generation. As a circuit judge for over 5 years and a practitioner in the courtrooms for 28 years before that, I have the experience to bring to the court. And folks, this has not just been a campaign for me. This is a commitment. I ran for this office in 2018. I want to be the best Supreme Court justice I can be. It's a commitment to the rule of law. It's a commitment to the betterment of the judiciary. But most importantly, it is a commitment to the people of the state of West Virginia.
And Senator Wooten.
Thank you. And I again want to thank the Stubblefield Institute at Shepherd University and the public broadcasting system for making this forum possible. An informed electorate is vital to our democracy. This forum would be valuable at any time, but in the time of a pandemic, it's invaluable. I also want to commend my colleagues, the other candidates, for their performances tonight and for their honorable and positive campaigns. And I want to thank those of you who are watching for your attention. I hope this forum is of some assistance to you as you determine who you believe will best serve the state of West Virginia as a Supreme Court judge. In closing, I want to respectfully ask that you consider my record of military and public service and the breadth and depth of my legal experience. I hope you will agree with me that my experience and abilities make Bill Wooten the most qualified candidate for Supreme Court judge. Thank you.
Thank you all. This concludes the discussion between candidates for West Virginia Supreme Court for Division 2. Thank you all for taking the time to speak to us today. We now move along to candidates from Division 3, and we'll send it back to David Welch at the Stubblefield Institute on the campus of Shepherd University to open the discussion with our third and final set of candidates.
Thank you, Dave. The candidates in Division 3 are Supreme Court Justice John Hutchison and attorney Mr. Bill Schwartz. Laura Dyer, who is a judge in the state's Fifth Circuit, is also running in Division 3. Unfortunately, she was unable to join us for today's forum. Each of the candidates taking part are invited to do a 1-minute opening statement. We will go in alphabetical order, beginning with Justice Hutchison and then Mr. Schwartz. Justice Hutchison.
Thank you very much, David. My name is John Hutchison, and I am currently a justice of the Supreme Court of Appeals, state of West Virginia. I began my career nearly 40 years ago when I was sworn in on May 20th, 1980 as an attorney in the Supreme Court. I've done a lot of things in my life. I have, I think, a unique set of credentials that makes me qualified to be a Supreme Court justice. I worked hourly rates as a carpenter, a construction worker, and a steel worker. I've also taught special education in the schools in Raleigh County, West Virginia. I've been a coach, and I've been a lawyer. As a lawyer, I was a member of a firm. I had to make payroll. We had about 25 employees. I then opened up an office for an insurance company in Charleston, West Virginia, and I had to take that office from a single person, which was me. And when I left, there were 10 people. Thank you.
Thank you, Justice Hutchison. For a 1-minute opening statement, Mr. Bill Schwartz.
Good afternoon. I'm Bill Schwartz, and I've been an attorney in Charleston, West Virginia for over 32 years, representing people in small businesses. I've also raised a family, a son at Marshall University and a son at Capitol High School. I'm a graduate of St. John's University, where I was a 2-time Big East medalist and Student Athlete of the Year. I took my scholarship money to Washington and Lee University School of Law, where I was a justice on the moot court board and regional champion mock trial team. I'm also been a trial lawyer, an award-winning trial lawyer for over 32 years. I'm here because I've never been a judge and I've never been a politician. I want to be a taxpayer among the roads. I want to represent the people I've been representing for 32 years as a watchdog for fairness and for respect for our tax dollars.
Thank you, Mr. Bill Schwartz. And now for our round 1 of questions. The first one goes to you, Justice Hutchison, and Bill Schwartz, you'll have an opportunity to respond. The question is, West Virginia is one of the states hardest hit by the opioid drug crisis. How can the court be of greatest help in combating our opioid drug epidemic, and what additional resources and tools should the court be considering?
The court can absolutely be a leader in developing ways to assist people that have been stricken by this crisis. Currently, the court is developing family treatment courts, drug courts, juvenile and adult, veterans courts, and truancy courts. Using these ancillary courts and specialty courts to help people, hold them accountable, yet help them have tools and be able to assist these individuals in not becoming recidivists, which saves the state money, which saves lives and families, and especially the children. The best way to save a child is to save the family. And the use of these, increasing use of these specialty courts to assist with this terrible, terrible epidemic that we've suffered in West Virginia will be of great assistance, and we'll do the best for the state.
Thank you, Justice Hutchison. Mr. Schwartz, you have 1 minute to answer the same question or to offer a rebuttal.
It's hard to rebut that. I agree. I believe our resources in the Supreme Court is in charge of resources for the entire court system, need to be focused on the frontline warriors. If you think of the virus and nurses and healthcare workers taking care of the front line, well, it's the family courts and the drug courts is the front line for the fallout of the opioid crisis. 7,000 children in state custody. Our resources need to be focused to help those people who are getting their hands dirty on the front lines, dealing with the day-to-day crisis that is a fallout from our opioid crisis. And I agree, we need to take care of the children first. They're our future.
Mr. Schwartz, thank you. I'm going to stay with you for this next question. I am standing here on the campus of Shepherd University in the Eastern Panhandle, an area of the state experiencing tremendous population growth. As a result, many observers claim our courts here in the 23rd Circuit are overburdened, as they might be in other high-growth areas as well. How should the reality of growing population in some areas and shrinking populations in other areas be addressed?
First of all, thank you. I agree. As you know, I've visited several times the Eastern Panhandle as part of my campaign last time and before the pandemic this time. And it is a growing area. You can feel the growth when you come to the Eastern Panhandle. That's not true in the rest of the state. That's not true in the southern part of the state. And there may be a time, and that time may be now, where we need to focus on where the resources are necessary to the growing part of the state, for the sake of the Eastern Panhandle and for the sake of the growth of the rest of the state. The easier we make it for businesses to find predictable results, for people to find access to the courts, the more people will be coming to the Eastern Panhandle, the more resources will be coming to the Eastern Panhandle, and the more tax revenue to the state of West Virginia. I couldn't agree more. I believe that we need to put resources to the fastest growing part of the state of West Virginia. And that's where you're standing right now.
Thank you. Justice Hutchison?
You know, it's a unique thing that we have to deal with here. Growing courts or growing resources to courts is a legislative function. I've been involved in the analysis and development of the courts through the Judicial Association since 1997. Every 8 years, there's a realignment study done, and the legislature takes that realignment and moves resources where they need to be moved or added as resources. The Eastern Panhandle, fortunately, and we are very aware of the growth up there, has gotten in the last 2 rounds extra judges to help them out. You also need help in your magistrate court system. Your magistrates are heavily overburdened. The problem is adding resources to those areas in forms of judges or magistrates is a legislative function. Of course, the Supreme Court supports putting resources where they need to be, when they need to be there.
Justice Hutchison, I'm going to stay with you for the next question. The West Virginia State Legislature considered, but did not pass, legislation to create a new Intermediate Court of Appeals. The current Supreme Court has decided not to take a position on this issue. Without taking a position on any specific legislative proposal, do you believe West Virginia would be best served by creating an intermediate court, and why?
You know, it's an interesting question, and we've been confronted with it for a year. You can make an argument both ways. The arguments in favor of an intermediate court of appeals would be that they could take on specific case types and develop the common law, and so that we would have a greater body of law to look at in terms of reaching decisions and helping judges get to the right results. The reverse side of that argument is that in West Virginia, appellate courts, the Supreme Court of Appeals only gets about 1,000 appeals a year. So if that court can handle it, then you have to look at, do you need the resources in an intermediate appellate court, or do you need the resources on the ground? For example, in the Eastern Panhandle, in the Charleston area, there are a couple areas in the South. Raleigh County is one, Mercer County is another, that have growing dockets every day. So those are the arguments for and against an intermediate appellate court.
Thank you, Justice Hutchison. Mr. Schwartz, 1 minute to answer the same question.
This one's an easy one for me. As a trial lawyer representing people in small businesses for 32 years, we don't need it, the intermediate court. We can't afford it, and it causes unnecessary delay. I truly believe justice delayed is justice denied, especially if you have a client with a limited life expectancy. I believe the resources that would go to that could be better used for those 7,000 kids in state custody and the growing needs for a court system and population growth like the Eastern Panhandle. There are better ways to use millions of dollars than create another court system, another level of bureaucracy, and I don't believe we need it. Thank you.
Mr. Schwartz, thank you. We're going to stay with you for the last question of round one, and the question is a 12-year term too long for the Supreme Court, and if so, what should the appropriate term be?
I'm going to be perfectly honest. I hadn't thought about this before, but I've always felt in the past, as being a lawyer here for 3 decades, that 12 years is a long term. I hadn't really thought of an appropriate term, but I believe maybe cutting it in half, 6 years. Obviously, the concept for 12 years must be for consistency in the court system. And when you have a judge, he's going to be there for a long time, and he doesn't feel the pressure of having to be elected every few years. But I think equivalent of a U.S. Senator, 6 years is plenty of time for a judge to relax and judge accordingly. 12 years is a long time. It's our current system. 6 years may be better for more accountability. So that's my off-the-cuff belief there.
Justice Hutchison, you have 1 minute to answer the same question or to offer a rebuttal.
Well, if you were to cut a Supreme Court appeals term to 6 years, then you're going to have to cut an 8-year term to 4 for circuit judges and family court judges, and then to 2 years for magistrates. That's inappropriate in my mind. I think 12 years is appropriate. You don't want judges out campaigning all the time or having shorter terms. The reason is exactly what Mr. Schwartz said at the beginning: consistency. You have the opportunity to elect 2 new members of the Supreme Court every 4 years. So the court has some opportunity to change. So I think 12 years is wholly appropriate. It does promote consistency, and it takes away the idea that somebody might be punished for a decision that they made at one point in time, and gives the people an opportunity to look at the whole term.
Thank you, candidates. I'd like to now turn it back to Morgantown to Dave Mistich for round 2 of the questions.
Thank you, David, and thank you, candidates. We'll continue with the same format for the second round. This first question is for Mr. Schwartz. West Virginia leads the nation in the number of abused and neglected children who are without homes. In addition, our state's foster child situation is in crisis. How can the court play a role in getting children the help they need?
I think this goes back to my response earlier. I'm well aware that there are 7,000 children in state custody, and I believe this is a fallout from the opioid crisis. I know we have it down here in the southern part of the state, and my experience speaking with people in the Eastern Panhandle and in the Morgantown area is that you also experienced the fallout from the opioid crisis. We got to get resources there. I know that was mentioned earlier that this is a legislative decision as to how to allocate resources, but the Supreme Court's in charge of $130 million. And if there is discretionary money within there, that needs to be focused to the frontline workers. And the frontline people in this crisis are the magistrate courts, the family court, the drug court, and the circuit court judges. Those are the people that get their hands dirty with it. Those are the people that need the help. That's where the money needs to go. And if I'm not running for legislature, but if the legislature should consider, they should consider also what you're going to pay the foster parents. Make it more palatable for them. They have to handle the children.
Justice Hutchison, you have 1 minute to respond or rebut.
clearly the courts have an obligation to take care of the children that are in the custody of the state. The courts make the decision to place the children in the custody of the state, and then the other, like the Department of Health and Human Resources, our probation officers, all have an obligation to work. You know, the problem we have is 85% of the $135 million goes to salaries and benefits for all the 1,500 employees that work for the Supreme Court. The court thereafter works diligently and has worked diligently through grants and other matters to increase our resources. Family treatment courts are a prime example of how the courts are trying to get resources out to the families and to the children to assist in getting rid of the problems. We all know that about 85% of our problems with the children in custody relate to drugs and opioids. That's every circuit judge knows that. Thank you.
Justice Hutchison, this next question is for you. Court abuses and subsequent reforms have been headline news over the past few years. Do you believe further reforms in the state's legal system are needed, and why?
I think that there's always room for improvement. This court, meaning the current court, has worked diligently since 2019 when I came on to develop policies and address issues inside the system that we have the authority to address. We've implemented 11 separate written policies. You wouldn't have thought we needed some of those policies. Common sense would tell you you don't drive a car out of state on a golf trip, but a state car out of state. But we've done that, and I think that a continued focus on the ethical obligations of judges and attorneys needs to continue, and we are doing that currently. And I think that keeping that focus there through training and other issues will help the system.
Thank you. Mr. Swartz, you have 1 minute to respond or offer a rebuttal.
Again, I have no criticism of anything Justice Hutchison may be doing or has done on the Supreme Court. We've got an image issue, and transparency is the key. Maybe even bringing legislative oversight, or more so than it is. And maybe, and that's why I'm running, maybe a taxpayer among the robes, someone who spent a career not as a politician and not as a judge, an alternative, not speaking against any respected judge and justice, but we have enough judges and politicians. I think one of the things we can do is put a taxpayer among the robes. Transparency is the key, and I think I'm going to work to bring that if the voters see fit to elect me to the office.
Mr. Swartz, we'll stay with you for this next question. The legislature passed judicial pay raises during the 2020 legislative session that increases the salaries of Supreme Court justices, circuit court judges, and family court judges over the next few years. Are you satisfied that the pay raises are sufficient to retain and recruit new candidates for those positions? Mr. Swartz.
I believe you get what you pay for. And I don't object to, of course, people are suffering right now because of the virus crisis. And some may consider maybe we should freeze whatever raises we've got. But I also believe you get what you pay for, whether it's a teacher, whether it's a fireman or a policeman, or whether it's a judge or a justice. And these are respected individuals. Every one of them is educated and intelligent. And we need the best people in that position. And you don't get the best people by not paying the best. I'm okay with the current increases. That's up to the legislature. But I don't object to increases. I understand that you get what you pay for, and the current increases are okay with me. Maybe some might consider freezing that because of the current crisis, but I understand it, and I respect that, and I respect the people doing the work at the judge level and at the Supreme Court.
Justice Hutchison, you have 1 minute.
You know, when somebody decides to become a judge or a family court judge or a magistrate or a Supreme Court justice, they're deciding to make a career change in the legal field. It's very unusual for a judge who leaves office to go back in and have a successful career as an attorney. You need to pay your people a reasonable, valued salary. The last raise the judges got was in 2011. I was personally involved as a member of the Judicial Association in every one of the raises we've gotten since 1997. They come on about 6 or 7 year cycles. The legislature created its own commission, which makes it really good because that commission decides what the value of a judicial officer is, and that's appropriate.
Thank you, sir. Justice Hutchison, this final question of this round is for you. More West Virginians are likely to experience the court system in the magistrate courts and family courts than either the circuit court or Supreme Court. As the leaders of the entire court system in West Virginia, what changes, if any, in the magistrate and family courts do you favor?
I would favor in the future some upgrading of credentials. It would be great, as in some other states, if magistrates were lawyers. But our public believes that an individual who is a common kind of person, common man, sitting as a magistrate has more appeal to them, and that's fine. The real thing that we need to do is keep training our magistrates. We need to require more training in specialized areas because even in the magistrate courts, commonly called the people's courts, the issues are becoming more and more complicated as we go forward, including domestic violence issues, child abuse and neglect issues, all the family stuff that they end up dealing with on a daily basis. And they need more and greater training to confront those issues.
Mr. Schwartz, you have 1 minute to respond.
Again, I have to agree. The family courts and the magistrate courts deal with our everyday issues. They have everyday people with everyday problems, many representing themselves. But I believe there must be more compliance with a set of rules. Not anything goes. And I also agree with Justice Hutchison that maybe a higher credentials for our magistrates, maybe a lawyer. But it helps people, especially when they're representing themselves, to have a person who knows the rules and who holds people to the rules. The rules are there for a reason. They help things go smoother. It helps the people representing themselves, and it helps the people who are represented by others. And it also helps the court system itself, the magistrate court or the family courts. I think more training is absolutely necessary, and maybe higher standards for the people who are in charge of our magistrate courts.
Thank you, gentlemen, for responses to all of those questions. We'll throw it back to David Welch at Shepherd, the campus at Shepherd. And David, I understand that we have time for one more question, as well as time for a minute of final statements, closing statements.
Thank you, Dave. Welcome back to Shepherdstown. Let's have a final question that both of you can answer. And that would be, should the state of West Virginia adopt sentencing guidelines in sentencing criminal defendants similar to the federal system, and should there be an increased use of alternative sentencing options for nonviolent criminals? We'll go first with Justice Hutchison.
I think that sentencing recommendations, uniform sentencing recommendations, as opposed to guidelines, in the federal system, they're not mandatory, although they have to. A judge has to justify going outside those guidelines. I think having some review of current sentences for each crime needs to be undertaken, but you cannot take away, I don't believe, the discretion of the judge in terms of imposing those sentences. And with regard to alternative sentencing, absolutely. We've got to start using more alternative sentencing for nonviolent criminals. And that would include training, treatment, if we can, if treatment is necessary, and a recognition that they need to pay back through community service, some sort of thing like that. Thank you.
And Mr. Schwartz, same question, please.
I'd love to disagree with them, but again, I have to agree. I was married to a federal prosecutor. I saw bad results from sentencing guidelines. Of judges objecting to sentencing guidelines, I think sentencing recommendation may be a good idea. And of course, I think with overcrowding of prisons, saving money for the taxpayer, non-violent, non-threatening people who are charged with crimes, alternative sentencing is a great idea. Public community service is a great idea. Whatever we can do to streamline what we're doing, whatever we can do to be more fair to the person being charged, so that everybody's treated the same, whether they're a poor man or a rich man. That recommendation sound like a good idea to me.
Thank you very much. That will end our round of questioning, and I'll send this back to Dave in Morgantown.
Gentlemen, you'll each have 1 minute for a closing statement. We'll start with you, Justice Hutchison.
Thank you very much. I appreciate the opportunity to appear and talk about some of these issues. I started a change in my life in January of 2019 when I became a Supreme Court justice. I did that because I felt like I had something to give with my experience and my dedication to this system for the last 25 years. I have the experience in the legal system, but also working with the administrative part of that. We've got a huge job in managing 1,500 employees and all the programs that we're trying to implement to better this system that was so horribly stricken down in 2017 and 2018. We're well on our way. And I think I have the qualifications, the experience, and the know-how to continue that program. And I ask the voters of the state of West Virginia to give me 4 more years to continue what has already begun and improve this system that is one of 3 equal branches and needs to remain so. Thank you.
Mr. Schwartz.
Thank you. And thank you to Justice Hutchison. He's the incumbent, and I appreciate the opportunity to be here with him. I'm not speaking to him specifically, but I did get into this because I felt that our court and our court system was lacking credibility and transparency. I did that 2 years ago, 3 years ago, and I did it again this time. I was concerned about the influence of out-of-state money and the appointment process. I still am concerned about that. I'm self-funded. Nobody's ever going to own me. And I'm doing this for, I believe, the right reason. Because I believe for my children and their children, I want a West Virginia that they can live in and not have to leave. I believe we need a taxpayer among the roads. And I think I'm going to be that taxpayer, that watchdog. We have enough judges and politicians, and some are very good. And I have no criticism of the man I'm opposing right now. If you want what things the same, you have an alternative besides me. If you think there needs to be change, I'm offering you a change. I want to be an agent of change for transparency, credibility, and a watchdog for the people that I've represented for 32 years of my life, my entire adult life. And may the Schwartz be with you.
That concludes the discussion from candidates from Division 3. Thank you both so much for your responses. We appreciate you taking the time to speak with us today. We'll send it back to David at the Stubblefield Institute.
Thanks, Dave. On behalf of the Stubblefield Institute, I wanted everyone to know how proud we are to have been included as a partner with WVPB, and a pleasure to also be a part of this wonderful debate. We remind you to vote on June 9th for your choice for Supreme Court Justice.
This concludes tonight's forum among candidates for West Virginia's Supreme Court of Appeals, sponsored by the Stubblefield Institute for Civil Political Communications at Shepherd University. If you missed any of tonight's broadcast, you'll find the program posted to our website, wvpublic.org. And one final reminder for Election Day, Tuesday, June 9th. Polls will be open from 6:30 a.m. to 7 p.m. But if you're among the thousands of West Virginians mailing in your ballot this year, it must be postmarked by Tuesday, June 9th. If you plan to hand deliver your absentee ballot, those are due at the county clerk's office the day before, Monday, June 8th. I'm Dave Mistich. On behalf of everyone here at West Virginia Public Broadcasting, thanks for joining us, and have a good night.
Support for the following program is provided by the Stubblefield Institute for Civil Political Communications at Shepherd University.
From West Virginia Public Broadcasting.